at the right time. Do you know what's on my mind? Can you stay for the evening? It's the little things that get me high. Won't you come with me and spend the night? Just a little thing for you and I.
Georgia Smith's new single, Little Things, is available now. Listen on Spotify.
Won't you come with me and spend the night?
Soundtrap is the easiest way of producing music. Simply select an 808 kick, add some sizzling hi-hats, add some weirdness with this broken glockenspiel, and finally let's pitch down and reverb this barking dog. Make a song in minutes. Use Soundtrap, an online music studio that's easy to use, highly collaborative, and works on any device. Try it for free. Just click the banner to get started. Soundtrap, your everywhere studio by Spotify.
peace of mind knowing what's coming next when you're listening. Turn off shuffle to tune into playlists and albums from start to finish, all while enjoying uninterrupted music listening. Discover more ways to stay in your zone with Spotify Premium. Tap the banner to learn more.
If you've ever thought, maybe I should start my own podcast, well, now's your time. Spotify for Podcasters lets you record from your phone or computer, then publish your show wherever podcasts are heard for free. Head to spotify.com/startapodcast and start recording now. Talk where the world listens with Spotify for Podcasters. Click the banner to learn more.
Hello everybody, welcome back to another stream. I'm here to do a study stream, Laws 121, and we are gonna first do our quant quiz because we are very late on that. So let me get some paper and a pen. Yep, well, let's get going. Camera's a bit foggy, isn't it? Let me get a wipe. Wipe it a bit with my finger. Okay, let's go. It's a little foggy still. Okay. 1, and 2. Let's go. Guess you can see my screen. Ooh, let's go. All right, we'll keep doing some study for 50 minutes. So study session. Let's do a quant statistics thing first. We'll probably go until 9 o'clock today. Statistics. Let's do quiz 10. How do I always get my password wrong? It's like I've learnt it wrong. What? Alright. Let's go to quiz. Let's go to quiz What's quiz 10? I can't even find quiz 10. What is going on? Statistic for business. Oh, quiz 10. I got 0 out of 8. There's unlimited temps, so it should be okay. Alright. Let's just have a look at this. A researcher finds that N hat P. A sample yields like 25 for composition as proportion. P is equal to 0.21. Correct. The phosphate is not random available, so our probability statement is incorrect. Okay. A random sample of people contains 134 homeowners, 206 who are not homeowners. What is the sample proportion of homeowners? You wish to test the null hypothesis P equals 0.3 using a sample proportion 0.61 and N equals 0.95. A researcher wishes to estimate a population proportion within a margin of error to 0.07. A pilot sample of 75 observation has a sample proportion of 0.8. Using the sample proportion, how large is the sample need to achieve the margin of error? A researcher wishes to estimate a population proportion to within a margin of 0.04. A pilot sample of 60 observations has a sample proportion using to 0.3. Using the sample proportion, how large is the sample is needed to achieve the desired margin of error? A lecturer wishes to calculate the average time spent on an essay within a margin of error 1.71 hours. A pilot study using a sample of 50 students produces a mean of 23 hours and a standard deviation of 10.3. Okay, let's actually watch the video first. Which I'm not allowed to stream these videos, they're copyrighted. Just the modules. Now let's have a look at the things. The quiz is due at... What time is the quiz due? 7 o'clock, so we have an hour. Oh shit, it's due in 2 minutes. Let's just go see every time and see what happens. See. Just answer C for everything. Try again. See you again. No, we can't get any marks. No. See. We can't. Come on, guys. Let's get a. Yeah, I got one. I got one correct. Okay, it's 7. Let's give up. Okay, let's go. We got a mark. Okay, let's go do law. Alright, so let's look at the exam. I need to get my notes. Right, I'm just gonna ring my friend Andrew. Hello. Woo! Just gonna mute myself one moment while I'll call my study buddy.
With ASB Card Tracker, it's easy to see your subscriptions in one place. The ones you use all the time, some of the time, and the ones you signed up to that one time. Keep on top of your ASB Visa card subscriptions with Card Tracker in the ASB mobile banking app.
You know what gets you moving, so why not get to the good stuff right away? With Premium, you can listen to music ad-free, get unlimited skips, and download playlists to listen offline. Enjoy unrestricted listening and upgrade to Premium. Tap the banner to learn more.
Alright, man. You can just chat on the stream. Alright, I will start. Okay. Alright, awesome, bro. I'm humiliating myself. Alright. You guys can hear me. Yeah. Okay. Let's work on copyright and patent law. Yay! Isn't that fun? I've got my paper notes here. Should I use paper notes or should I use digital? Let's go digital for once. Alright, let's go Cornell notes. Cornell notes are easy. Okay, 50 minutes of solid practice and we take a 10-minute break after. Alright, that's how I do my study. Skip breaks, 50 minutes solid. Let's go. 50 minutes of solid study and then we can go do some fun. Honestly, I don't know why I use Evernote. It's like there's something about it that I really like. Okay, let's see. How to help Jim. How to help Nico Jung. Yeah, let's move. How do I go to? There we go. All right, so we are going to go to Notebook, and we're gonna go to Bachelor of Laws. And you know what? Let's just put in miscellaneous notes. Okay, let's copy and paste this template. Let's put it in miscellaneous notes. I'm gonna prepare the Kahoot later on. Bro. Andrew, can you answer questions in the chat if there are any? If anyone's watching. Alright, so let's go date 24th of the 5th, 2023. Let's go topic copyright and trademark law. Subject is law, obviously. Okay. Let's go. The question is, what is a case study for copyright? Let's do a case study. Copyright law for trademark law in Aotearoa, New Zealand related to iPons Ed. There we go, that's a good question to put in. And we just put here key questions. No questions, no. Yeah, key terms. And at the bottom we put questions. What questions do we have? And here we just go, yep. And yep, okay, that sounds great. Alright, let's go. Let's put this away. Half the size. Okay. Alright. Let's put this down. I'd actually like to learn about this. So what is iPons NZ? I'll just shout out to Tara for telling me about it. She told me a whole lot about copyright law. So that was very cool. Intellectual Property Office of New Zealand. So ipons, that's to the Intellectual Property Office of New Zealand. That's awesome. Let's have a look at what they do. So I need to apply for a trademark for Kiang, huh? So about IP overview. Intellectual property IP includes trademarks to distinguishing your goods and services, patents for new inventions, designs for the distinct aesthetic of your products, plant variety rights for new varieties in agriculture or horticulture, geographic indications of wines and spirits that are characteristic of a particular location, copyright for your creative works like books, paintings, and software. Oh yeah, I'm going to be hosting a post-exam party, not just for Laws 121, but for everyone who's at Vic Uni. All 22,000 people are invited. But tickets are going to be $5 each. And yeah, everyone in Laws 121 gets to go for free. So yeah, it's going to be really cool. Trademarks. Okay, let's see. IP is independent. IP is fundamental for most businesses and is a tool for creativity, innovation, and even education. Some IP rights may be registered, which gives you certain exclusive rights of your brand, innovation, or expression of your idea. By protecting your IP, you may gain a competitive advantage in the marketplace, enabling you to profit and grow your business. This is actually quite relevant for me because I run my business selling dumplings. Dumpling Son. Gao Dai is the name of my thing. So let's go. Intellectual property. Oh shit, what the hell? What is going on? Let's put some dot points in here. According to ipons, intellectual property includes 1. Trademarks to distinguish. This is 7 solid paragraphs you could write about. Distinguish your goods and services. Let's go to patents for new invention. I'm just typing it so I remember. Designs for the distinctive aesthetic of your goods. Products for plant variety rights for new varieties in agriculture or horticulture. Geographical indications for wines and spirits. Go away. Oh, it's an ad.
It's most likely more than one, since music making is way more fun together.
That are characteristic
that lets you collaborate on projects in real time.
For a particular location.
Subscribe now and get a 1-month free
6. Copyright. See, copyright's automatic, isn't it? Though copyright
soundtrack. Your everywhere
for
studio
your
by Spotify.
creative works like like books, paintings, and software. I'm gonna add something to my to-do list. I want to add find copyrighted free music. It's a bit loud. Find copyright-free music for streams. Find copyright-free music for streams. And we'll set a due date this Friday. Actually, how many things do I have on my to-do list? Oh shit, I got 7 of them. We'll just make... Next Monday, that's fine. Work on earn. Oh, we need to... We can't do those anyway. Alright. Yes, intellectual property stream. Check Nuku calendar. Have we even done that? Let's go to Nuku. Nuku. Did we post on Twitter today? I don't think we did. Twitter. I can't even remember. Did we post on Twitter today? I think we did. Okay. My Twitter is Kiangster, just like everything else if you want to go on it. Let's go to Twitter. Let's post a Twitter photo. How do I rotate? It's like... Company logo! Company logo. Yeah. Okay, there we go. Okay, we posted on Twitter, our to-do list task is finished. We did not go to the IID today. We need to go to the IID. Can we just go on Friday or something? It's kind of important. And we just have to check the Nuku calendar. Where's the Nuku calendar? Nuku. Check the calendar. Do we have anything due? Let's see. Okay, we finished our quiz today, so we have nothing due. Topic 7 topic test is coming up. That's about it. I missed quiz 4 and 3. I feel so pissed. Anyway, that's one task done. So now we finished that task. We've just got one task on our to-do list. Okay. Let's go back to intellectual property law. So basically, in summary, intellectual property law is law that covers intellectual property rights, which is intellectual property rights are rights of a business to have exclusive use of their trademarks and certain products that they make. Let's go define intellectual property rights definition. Okay, here we go. According to the ministry, intellectual property refers to new innovations and creations of mind. Okay. Intellectual property intangible property that is the result of creativity and innovation and comes from the mind. That is cool. Anyway, what are rights? Let's say the rights are easy. Rights. Things you are automatically. Things you are entitled to. That's about it. Keep it simple. Two. I made the questions myself, Andrew. Myself for my notes. Yep, but I'm gonna share these notes if you'd like them. I'll put them up on the Facebook. Let's go story time. Let's find some case studies. Where can we find some? If we had a library, that'd be good. I would love to do aviation law. That would be fun. Okay, so intellectual property. Famous intellectual property cases in New Zealand. All of the famous. Oh, here we go. Pfizer versus Commissioner of Patents. Let's do one. This one looks let's not start with the. Okay, this one looks interesting. Oh, ooh. Coombe versus Coca-Cola. It looks interesting. And ooh, tobacco and milk. Now that's interesting. There we go. Okay, what happened here? Where did my notes go? They just disappeared. They decided to bugger off. Oh, here you go. So let's go look at some cool cases. Let's go. Pfizer. I like the name. Pfizer. It's like a pie with a P sound. Pfizer. In Korean, the P and F sound are pretty much the same. Versus Commissioner of Patents. Pfizer versus the Commissioner. Why am I saying Commissioner? Pfizer versus the Commissioner of Patents. Let's start with that case. So let's go with the facts. Let's do the. Let's go. Use CLEO method, which is basically not method. Claim, law. I go evidence and evaluation. Evidence and evaluation, and outcome. So let's go. What's the claim? Let's have a look at the text. Let's have a quick skim read first. Man, why is half the slide not visible? It's stupid. Okay. On the 28th of June 2004, the New Zealand Court of Appeal delivered a unanimous judgment rejecting Pfizer's appeal against the High Court judgment that concurred with the Commissioner of Patents' rejection of 2 applications to patent methods of medical treatment. So, we can probably just skip claim, law, evidence, and evaluation. And outcome. So outcome, we can skip to that. That's pretty easy. The New Zealand Court of Appeal delivered a unanimous rejection of Pfizer's appeal against the Assistant Commissioner of Patents who refused a patent to patent applications regarding methods of medical treatment. That's a sit. I like that. See, the sentence gets straight to the point. Treatment. New Zealand what?
Want to make the most of your playlists?
On
With
28th
Spotify Premium, you can listen to
of
all the
June
songs that fuel your
2004.
fire without hearing ads. Play it loud and play it proud without music interruptions. Upgrade to Premium.
See,
and listen
medical
your
things
way.
shouldn't be treated as so
Better to learn
exclusive.
more.
They should be shared. I agree. Actually, I can't make a judgment without reading it first, can I? Alright, let's put this in. Court of Appeal,
Soundtrap by
2004.
Spotify is an easy-to-use
And we put that
online
in
music studio.
brackets.
Created by
this.
musicians and producers,
And we
the
can
Soundtrap Studio was
italicize
developed to
it.
make the recording
Alright.
process easier, so that you can focus on the creation with thousands of
On the,
professionally
so,
recorded sounds
okay,
already in
the
studio.
patentability of methods of medical treatment was first substantially tested in New Zealand's Wellcome Foundation Limited versus Commissioner of Patents. The Court of Appeal in Wellcome overturned. Alright, so law. So the law we have is New Zealand. Oh, such a long. New Zealand. No. Law. Wellcome Foundation Limited. Limited versus Commissioner of Patents. So this is a government agencies, I'm guessing. Commissioner of Patents. It is, right? Commissioner of Patents. Yes, excuse my bad spelling. So, oh, okay. Alright, so methods of medical treatment cannot be patented. I don't really get what that means. Painted in on policy grounds. What? Let's put a question here. Aye, so dirty. What was Wellcome Foundation versus Commissioner of Patents 1983 FSR 593 about okay. And that patentability, that's a weird word, patentability could only be made by the legislature. These matters. This subject matter. Add to dictionary. Yeah, it's now part of the dictionary. And why is welcome with 2 L's? Ignore. Is there an ignore? There's no ignore button. Okay, we'll deal with that. In the current appeal, Pfizer initially argued the Pharmac decision overruled Wellcome. respect to dependent on medical treatments. The Court of Appeal rejected this argument, finding that Pharmac only revealed and finding that Swiss type claims are. I don't even know what that means. Okay. Let's just highlight this. Let's highlight this a different color. We go straight to. I usually go to orange. Then I'll go to pink. In that case, we'll go to red. That's the closest to pink I've got. Oh no, we do have pink. Outcome. And that should be in yellow. No, yellow, yellow, yellow. Pfizer argued that Pharmac, what on earth, overruled Welcome, but the Court of Appeal rejected that. Under the Act. Patents Act, right? Patents Act, I think it's 1985 or 2013. Patents Act 2013. Why is it still highlighted? Unhighlight. How do I unhighlight? That makes no sense. There we go. Patents. Patents Act 2013. Okay. Pfizer also sought to argue that Welcome should be overruled on account of subsequent developments. Namely, Pharmac acknowledged that methods of medical treatment could qualify as an invention under the Act. What is Pharmac? What is Pharmac? What legal... Put one here and we'll put an answer box. What legal precedent did Pharmac create? IPONS is the intellectual property office of New Zealand. One of our classmates mentioned it. All right. Why do I have this? That's odd. See, so much time spent on one case. Okay, let's be quick about this. We have about 25 minutes left to study. So let's smash this out. Alright. How that medical treatment. However, in the present case, the Court of Appeal held that while a method of medical treatment can qualify as an invention, it could still be excluded by Section 6 of the UK Statutes of Monopolies, 1623.
For a limited time on selected chiropractic beds. New Zealand Chiropractic endorsed for the ultimate in back support, and now half price. Beds are us, where dreams begin.
Alright, Pfizer.
Get peace of mind knowing what's coming next when you're listening.
Pfizer
Turn off
made
shuffle to
the
tune into
claim
playlists and albums from
that
start to finish,
two
all while enjoying
of
uninterrupted
its
music
medical
listening. Discover more ways to
treatments
stay in your zone with
were-
Spotify Premium. Tap
What does
the
it
banner
say?
to learn more.
Pfizer also sought to argue that it should be overruled on account of subsequent developments. Namely, Pharmac acknowledged that methods of medical treatment could qualify as an invention under the Act.
Add some weirdness with this cowbell. And finally,
Were
let's push it down and read with this
inventions
sparking dial. Make a song in
according to
minutes.
the
Use Soundtrap, an online music studio
Patents
that's easy to use,
Act
highly collaborative, and works on any
2013.
device.
Pfizer made the claim that two of its medical were inventions according to the Patents Act
Your everywhere studio
and
by Spotify.
could be patented on the grounds that medical treatment could qualify as patents according to the Pharmac case. Alright. Between the court also held that the statutes of monopolies is not overruled by the obligations to the TRIP agreement. What's the TRIP agreement? I don't even know what this is. TRIP agreement. TRIPS. Oh my gosh. But okay. Agreement on trade. That's getting international law now. Related aspects of intellectual property rights. Intellectual property rights. TRIP. Is it called TRIPS agreement? TRIPS agreement. TRIPS. When was the TRIPS agreement signed? It was signed in 15th of April 1994. Wait, I can't. Short-term memory loss. 1994, right? We should put brackets around it. The courts rejected Pfizer on the grounds that Section 6 of the UK statute of monopolies 1623 that section was permitted could constrain what could be patented. Let's have a look at this. UK statute. Statute of Monopolies 1623. Oh my gosh, that still applies in the section 6. Oh my gosh, that is quite the ancient document. I want section 6. How far does it find? Oh my gosh, this is so old. Oh. Oh, okay. So let's read this. Because this is kind of interesting. I'll skim read it and summarize it for you guys. Who writes like this? Okay, I have no idea. I'll just copy and paste this. What does the UK Statute of Monopoly 16? This section of Statute of the UK Statute of Monopolies mean? That is quite the question. You know, let's email Paul. Let's email Paul. Let's do that. I'll see you in an email. I'll email him after the stream. Let's go, Paul Scott. Okay, let's email him. You guys can see my student name at my vw.ac.z. It's fine, I'm class rep anyway.
Stay for the lifestyle. The Victorian Government in Australia is offering generous financial incentives to early childhood teachers and head teachers who make the move.
No, don't say that.
Relocation support is available, including to those moving with families. Find out more information on job opportunities across Victoria at vic.gov.au/kinder. Authorised by the Victorian Government, Melbourne, Australia.
Yeah, can I get bacon with extra bacon and bacon sauce? KFC
Pfizer
with double bacon, double cheese,
versus
and original recipe fillet, creamy bacon eggs, and a brioche bun. Here for a limited time.
Commissioner of Patents. Go away. What is this? CA 2004. Kia ora, Paul. I was looking into the case above regarding patents. It discusses discusses the UK Statute of Patents. Statute of Patents, right? I think that's what it's called. Statute of Monopolies, right? Statute of Monopolies, 1623. Discusses section 6. I didn't understand this section, so please could you interpret it for me, including its legal significance today. There we go. They'll send us email. There we go. Alright, easy. Oh my gosh, we're almost running out of time. Oh, can we just go to another case? Well, I've still got a couple more to go. Alright. Pfizer's last argument was the court has clarified the scope of the Commissioner's ability to refuse an application on the basis of being generally inconvenient. It also held that it could reject applications on the basis of being generally inconvenient. Assistant Commissioner, what is this website? Pipers. Assistant Commissioners AC decision overruled part of the director's note related to so high type the AC decision. We'll just put the source in here. I wonder how good Piper Rat is. For legal professionals, let's have a look. The following pages aim to provide relevant information regarding intellectual property law and practice in New Zealand and Australia, including general information on the governing legislation, links to actual legislation, and summaries of important cases in this field. Also included is information on the IP offices of each country, including a list of days when the offices are closed for holidays. If you are a small to medium New Zealand or Australian law firm who does not have an IT department, we're happy to work with you. Pipe is able to play a prominent support role on behalf of legal firms. Alright. Let's put here. Good website to use. If you're lays with a number of firms who require our specialist skills or are in need of a competent firm with sufficient resources to handle workflow within stringent time restraints. We can assist your clients with advice on all IP matters as well as with drafting, filing, and prosecuting local and international patent, trademark, and design applications. We can prepare comprehensive patent design and trademark searches for your clients and prepare IP-related diligence reports and substantive opinions on litigation and enforcement matters if required. That looks good. I like this. Pipers. Piper's intellectual intellectual property, and we'll just put Piper out. Alright, that's awesome. Let's go Coom versus Coca-Cola. Okay, after the timer goes off, we'll spend the last 2 minutes. Let's be quick about this. Let's be really quick. Okay. What just happened? What? Why do I have neither? That's. Why is that a thing? Okay, let's go back to this. Okay, we are just bolding this, Jesus. There we go. Coom versus Voom and Coca-Cola. Amatil, I don't know what that is. Never heard that. NZLTD 2010. Okay, let's go. Same template. Draw B. Claim. Law. Evidence and evaluation outcome. Claim. Claim. Law. Let's do it in one sentence. We can do it one sentence.
With Premium, get right to what you love and skip the rest. That
What the hell? How do I
means only
drag
what you
a set
want
of
to hear
colons
with
that way?
unlimited skips and listening to music
I'm
ad-free
thirsty.
on any device. Upgrade to Premium and listen your way. Tap the banner to learn more.
Coom was unsuccessful in appealing an assistant commissioner's decision that allowed the registration of the phrase "world famous" in New Zealand in Class 2032 by Coca-Cola. Coca-Cola has made substantial use of the phrase in relation to the relevant goods since 1923 and applied to register it in 2004. Coom submitted the phrase as a descriptive slogan that has entered everyday language in New Zealand. Coom tried to appeal against the assistant commissioner's decision that allowed the phrase "world odd famous in New Zealand." Coom tried to appeal against the assistant commissioner's decision that allowed the phrase to be patented on the grounds that it has entered everyday language in Aotearoa. My typing is so bad. Language in Aotearoa, New Zealand, but the court ruled in favour New Zealand. Coombe submitted that the phrase is descriptive of an interpreted language. It is now used and understood in various situations and also law. The judge considered the relevant market to be the bulk as large, however, taking account of experience and views of the public should not result in the distinctive test being applied in this matter. Okay. What is the distinctiveness test? Okay. The judge held that being well known and having other applications is insufficient to make the phrase descriptive. Descriptiveness needs to be evaluated from the use of the phrase in trade, and in particular whether competitors would be hindered in their use of descriptive or laudatory words for their products. Here, the evidence did not establish the phrase to be descriptive or generic in the relevant trade. Neither is the phrase laudatory. I don't even know what laudatory means. Let's have a look. Laudatory. Expressing praise and commendation. That's what I thought. Applause. The judge noted that being meaningful... Okay, we finished this focus session, let's be quick now. The judge noted that being meaningful when applied to other types of goods does not make the phrase devoid of distinctive character. The judge said that the phrase is a fanciful oxymoron logo that produces a quirky, original, and distinctive incongruous and self-contradictory statement. It stands on its own as being a badge of origin that distinguishes Coca-Cola's goods and is not a limping mark. Hence, the mark was allowed to proceed with registration. Okay. Well, the law that's relevant is the Patents Act, obviously. Patents Act 2013. Distinctiveness. What is it? Distinctiveness test. I think that's common law. What is the distinctiveness test? Judge held that the phrase is a fanciful oxymoron. The judge allowed the mark to proceed with registration. I think the Patents Act and the Trademarks Act 2002. Okay, we should probably research those acts. Then we'll put other cases. Let's close this. NV Tobacco Trading Company and New Zealand Milk Brands Limited. intellectual property cases in NZ. Let's just copy a couple. This one looks interested. Oh, this one looks interesting. Alcohol, that's interesting. Just put this down. Okay. Commissioner, let's search this up. Wellcome Foundation versus Commissioner of Patents. Let's have a look at this.
Georgia Smith's new single, Little Things, is available now. Listen on Spotify.
Won't you come with me and spend the night?
We need to put this into small again. In 1983, the New Zealand Court of Appeal found methods of medical treatment on humans to not constitute patentable. We can just put this. So medical treatment cannot be patented. And we'll put a source. Source. Pharmac case. Pharmac case. Pharmac case. The court ruled that New Zealand is bound by the TRIPS agreement that obliges it to provide protection of all inventions without discrimination. In the view of the court, claims on the use of known Why does a link keep coming up? That's so dumb. I've never seen anything. I don't want to copy. Oh no, nothing important. Okay. The rule that New Zealand is bound by the TRIPS agreement that obliges it to patent protection for all inventions without discriminations. The Court of Appeal ruled that New Aotearoa New Zealand that Aotearoa New Zealand is bound by the TRIPS agreement. Agreement 1994 and must provide patent agreement without discrimination. I will just copy the link. See source. I will download. I want to download this. Just email it to myself. Wait, sorry. Okay, I'm back. To intellectual property cases to download. Hi, Kyle. Please download both to law folder. Kind regards, Kingster.
What if you could pursue the career you love and enjoy all the wonders that Australia has to offer? Are you ready to teach in Victoria? Visit vic.gov.au/teach the future. Authorised by the Victorian Government, Melbourne.
There we go.
Is music your whole personality?
We're not judging here. In fact, we're offering a helping hand.
On the Tahi, we consider ourselves experts in the field of fresh local music.
Upgrade your talking points.
Great to hear.
We're right here on Spotify with new episodes every Tuesday and Thursday.
Okay.
With millions of songs at your fingertips, your playlists are always a work in progress. With Spotify Premium, listen to your music without hearing ads to keep your
Yeah, let's get back to our
musical
work.
exploration
A bit
going
distracted.
24/7. Upgrade to Premium
Okay,
and listen
let's see
your
if any
way.
questions.
Tap the banner to learn more.
What is the distinctiveness test? Test in law. A legal principle where only trademarks that are inherently distinctive or have demonstrated the capacity to be distinguished. A legal principle where only trademarks that are inherently distinctive or have demonstrated the capacity to be capacity. A legal principle where only trademarks that are inherently distinctive or have demonstrated. A legal principle where only trademarks that are inherently distinctive or that can demonstrate the capacity to may be registered. Okay, let's summarize this. What? Let's have a quick skim read and then we'll get done. Okay, let's read it. What is a case study for trademark law in arbitration related to the intellectual property of user iPods? Well, one example of an intellectual two example of intellectual property cases with significance in New Zealand are what is it? Coombe versus Coca-Cola. Well, let's go first one. Pfizer versus Commissioner of Patents, 2004. Pfizer and Commissioner of Patents, Court of Appeal 2004, and Coom and Coca-Cola Amatil, is it Amtil or something? It was Amatil NZ. Amatil NZ Ltd 2000 and I was 2010 which both concern patents. In the case of Pfizer, the court ruled that both applications on two medical treatments should be rejected on the grounds that the commissioner can refuse patents on the grounds of being general inconvenient, being of general was it inconvenience? Being general on the grounds of being generally inconvenient. Meanwhile, in Coca-Cola's case, it found that the phrase world
With ASB Card Tracker, it's easy to see your
famous
subscriptions in one place,
New
like the music streaming services you
Zealand.
listen to, the podcast streaming services you listen to,
Episode of Mysteries Explained.
the audiobook app you listen to,
was
and les
distinctive
applications pour répondre les langues. If you're still
enough
using that language
to
app you subscribe
warrant
to, you'll know what I just said.
a
Keep on top of your
trademark.
ASB Visa card subscriptions with Card Tracker
In
in the
both
ASB
cases,
mobile banking app.
precedent regarding distinctiveness and the powers of the Patents Office. In both cases, and the powers of the executive patents. In both cases, precedent regarding distinctiveness and the powers of the executive department regarding patents. In both cases, precedent regarding distinctiveness and the powers of the executive patents is very significant. Today, the intellectual property office of New Zealand, IPONS, regulates and administers the Trademarks Act 2000. So 2002 and the Patents Act 2013, which ensure intellectual property such as slogans, trademarks, varieties, agriculture, types of wines, designs, and other creative and innovative properties. Properties are protected. Okay, let's save these. Okay, just copy and paste this. We can put it to Word and let's put it in here. Layout has to be A3. Let's go fix it. Don't save. I'm going to share this somehow. Share. How do I export? Export as PDF. Okay, pages. What do I go? A5, A2. Oh, A4 should be good enough. No, I go A3. I like A3. It's got its own page and everything. Page 2, 3, and 4. Let's go. Desktop. Covers documents. Professional life. No, we're not moving that. Study. And we'll just go HGF. Okay. HGF, and then we'll print pages 2, 3, and 4. Two to 4. law stream IP law notes stream tube stream 24th of the 5th 23. Okay, we'll get rid of this. Let's put this up on my notes from my YouTube stream regarding intellectual property. There we go.
With ASB Card Tracker, it's easy to see your subscriptions in one place. The ones you use all the time, some of the time, and the ones you signed up to that one time. Keep on top of
Hello,
ASB
William.
Visa
How are
card
you?
subscriptions with Card Tracker
Hi,
with the
Will.
ASB mobile
How
banking app.
are you? Sorry, I don't actually get to see. Alright. Oh, I don't want to hear about that. Please stop talking. Okay. Let's take a 10-minute break. I'm so tired from studying.
Soundtrap by Spotify is an easy-to-use online music studio. Created by musicians and producers, the Soundtrap Studio was developed to make the recording process easier so that you can focus on the creation. With thousands of professionally recorded sounds already in the studio and a simple online interface, you'll have everything you need to get started. Subscribe today and get a 1-month free trial. Soundtrap, the online music studio by Spotify.
That's good, that's good. What do you study, Will? Maybe I should do a stream about what you study. Maybe we could do a revision session. It wouldn't be much help to me, but hey, maybe students at UNSW or USyd might want to watch, huh? Man, I'm so exhausted. I want to take a 10-minute break. 10-minute break timer. Alright, I'll be back in 10 minutes. Yep, alright.
moment with complete control over what comes next. Well, at least when it comes to your music. Spotify Premium lets you play albums and playlists in any order. No ad breaks. Just uninterrupted music listening without limits. Tap the banner to learn more.